Just a second. Now you can.
Good afternoon, Your Honors.
Good afternoon.
My name is Stephen Roberts, and I represent Hollie Cherry in this matter that is an appeal from the Juvenile Court of Shelby County, Tennessee, and I would like to reserve 3 minutes for rebuttal.
3 minutes, all right, sir.
And just a little procedural background, this matter is an appeal from Shelby County Juvenile Court under the old procedural system where they had a hearing and then you could request a rehearing and then appeal from there, and that's where we are on this particular case. The parties in this matter are the maternal grandmother, Hollie Cherry. She is the mother of the appellee, Lori Moss, who has filed nothing in this proceeding, and that'll become clear in a few minutes. She's now living in Florida, we believe. And the father is Christopher Tyler Moss. And the child in question in this particular action is Eli. It's Christopher Elijah Huffman, but everybody refers to him as Eli. Just briefly, Lori Moss became pregnant when she was in high school at 17, and Mr. Huffman was the father. The child was born, and Lori and Eli lived with the maternal grandmother from 2011 to 2019. So we've got a 8-9 year period there that the child lived in the maternal grandmother's home. And during that time, of course, the maternal grandmother assisted in caring for the child, you know, taking the child to school, daycare, everything that you would expect with a child living in the home. In 2019, Lori and Eli moved to DeSoto County, Mississippi. Lori became involved with another man, Will Moss. They eventually married, but they had a child as well, and that child was Ronan. During the period from 2019 to 2021, again, the maternal grandmother visited weekly, kept the children on weekends, would even go to Eli's school, have lunch. All of that's in the record. And in the spring of 2021, Lori and her new husband, Will Moss, asked the maternal grandmother for money. They wanted to open a gym in DeSoto County, and the grandparents refused. At that point, Lori cut off all visitation with both children and said, "You can't see them." Now, backing up a little bit, with Mr. Huffman and Lori through the years between the birth of the child in 2020, they had been in litigation over child support and custody numerous times. And as you can imagine, the relationship between the maternal grandparents, Lori's parents, and Mr. Huffman was not a good relationship because they'd been in court many times. In August of 2021, Miss Cherry, Hollie Cherry, filed a petition for grandparents' visitation rights in Tennessee in juvenile court concerning Eli, and in the Chancery Court of DeSoto County concerning Ronan, the other child. And the DeSoto County case was heard first because, of course, this was during COVID and it was trying to get things heard, and getting Zoom hearings in juvenile court was a little difficult. But in December 2021, the Chancery Court in Mississippi awarded Ms. Cherry basically the third weekend of every month with Ronan.
So
We get to.
that case has nothing to do with our case.
Excuse me?
correct?
That
case has nothing to do with
It is not this case. And the only reason I mention that is because when we finally got to a hearing in the spring of 2022, the juvenile court judge that granted the initial grandparent visitation set it up to mirror the Mississippi visitation. That's why.
Thank you for explaining that.
It was set up where there was a visitation the third weekend of every month, and this hearing, I believe, was in first part of May of 2022. In 2022, after the order, Mr. Huffman, for lack of a better term, denied grandparent visitation to Miss Cherry. She went to the house. Tyler Huffman would not make or tell Eli he needed to go. He would send Eli out to the car and say, and in hearing distance, that he didn't want to go. Well, of course, his father's right there listening. At the same time that was going on, the Mississippi contempt action was going on because Lori Moss in the Mississippi action was denying visitation as well concerning Ronan. And again, that is not this case, but it's important to this case because at the same time that Mr. Huffman was denying visitation concerning Eli, he actually took Eli to the Mississippi Chancery Court contempt action, which was being held in Senatobia, Mississippi. He brought Eli down to talk to the guardian ad litem and possibly testify in that action. It is Mr. Huffman that was sticking Eli in the middle of all this. And I say that because when we finally got to a hearing before, well, let me back up before we get there. Mr. Huffman denied the grandparent visitation May, June, and July. A contempt action was filed against Mr. Huffman in August of 2022 for the denial of visitation. In September of 2022, Mr. Huffman decides at his attorney's request to seek out a counselor to address the issues of the stress and strain on the relationship. And again, he didn't do that until after the contempt action was filed. And that's where Counselor Browder testifies at the hearing that was heard in November of 2022. But the point to that is that the counseling didn't occur until after the contempt action was filed. And then when we have the hearing, finally in November of 2022, James Browder is called out of turn just for convenience because, it's not a jury trial, it's just the judge, so he's called out of turn. And he testifies that, this is a big stress factor for Eli about visiting with the grandparent. But when asked, he did not know that there was a contempt action against Mr. Huffman. He did not know that there was a contempt action against Lori Moss in Mississippi that Mr. Huffman took Eli to without a subpoena or anything. He voluntarily took him to court. He did not know that there was no visitation between the mother and Eli because after the hearing in Mississippi on the contempt action in July of 2022, Miss Moss, Ronan, and her new husband moved to Florida, which we found out later, but basically disappeared. And from August of 2022 through the time of the hearing in November, Eli had not seen his mother, because she was supposed to have week on, week off visitation, left him. And again, the counselor didn't know anything about that either. And so when you look at what the counselor knew and what Mr. Huffman was telling him, his 4 years of experience in testifying is really, or his 4 years of experience as a counselor, really raises questions and concern. But we come down to the issue is, at the trial, there was no dispute that Eli lived in the grandmother's home for 9 years, or 8 to 9 years, from 2011 from birth until 2019, and that there was a continuous relationship after that. At the trial, Ms. Ball moves to dismiss based on failure to prove substantial harm. It's our position that pursuant to 366306A5, that burden, because the child lived in her home for more than a year, that burden shifts to the father to produce that evidence. And with all respect to Judge Glasgow, he said the burden was on the mother to prove substantial harm. The statute by itself under 36306A5 states that this particular section establishes a rebuttable presumption that the denial of visitation may result in irreparable harm.
That's the same thing as substantial harm?
Excuse me?
Is that the same thing as substantial harm?
Yes. It's our position that it is. And there have been a couple of cases, one involving, well, there are 2 incidents where the statute, this particular statute, creates a presumption of rebuttable harm. And that is one where the parent is deceased. Okay, I guess I'll have to reserve the rest.
No,
for
go ahead and finish your statement.
Okay. There were 2 instances. One was where the mother, rebuttable presumption exists under the statute. One is where the parent is deceased, and there's a case of Watkins versus Watkins, wherein that held that the statute shifts the burden from the grandparent to the other party. And then in Chamberlain versus Brown, it was actually one where the, under 36A5, where the court held that the mother failed to rebut the presumption. And so the presumption is there, and it's up to the mother, or in this case, the father, to rebut it. And because of the procedural statute, procedural position that we were in, the father never rebutted it. Judge Glasgow just ruled.
Thank you.
Good morning, Your Honors.
I think it's
Good
afternoon.
I've been here since morning. I haven't been at the Court of Appeals in almost 20 years, and I decided to drive in and hear the 9:30 docket so I would know where to stand.
Well, I hope you enjoyed it.
I did enjoy it. My name is Sabrina Ball, and I'm with the law firm of Moskovitz McGee in Shelby County, Tennessee. I represent Mr. Christopher Tyler Huffman in this matter. Your Honors, as stated by Mr. Roberts, Tennessee Code annotated 366306 governs the grandparent visitation statute. Your Honor, the Constitution strictly prohibits any judicial assumption that the grandparent-grandchild relationship always benefits the child, which hurts my heart as a grandmother, but the Constitution says what it says. This is contrary to a parent's fundamental right to raise a child as they see fit. And there's an assumption under the law that fit parents are acting in the best interest of their children. There's no dispute in this case that we have two fit parents. There's nothing in this record to indicate Lori Moss is unfit, and there was nothing in the record to indicate that Mr. Huffman was in any way unfit. These parents made a decision together that they didn't want their child, Elijah, who's now 13, to be exposed to certain individuals. That was the appellant, Hollie Cherry, and her husband, Roger Cherry. They didn't close the door on these parents continuing to have a relationship with these two children. They put in a parenting plan that the court adopted, that the grandparents should go to counseling. And after counseling, they would revisit grandparent visitation rights. Instead of taking the counseling path to repair their relationship with their daughter and her new husband and the new baby, the appellant Hollie Cherry filed two separate lawsuits, one being in Mississippi and then the one being in Tennessee that involved Mr. Huffman. Mr. Huffman had equal parenting time at that point, and Mrs. Cherry decided she couldn't get it from her daughter, the parent, some visitation, that she would encroach upon Mr. Huffman's equal parenting time and ask for visitation while the child was with Mr. Huffman. The grandparent statute requires the court to do a certain analysis to see if the grandparents qualify or have standing. There was no dispute in this case that these parties were never married. So pursuant to A2, that states the child's father or mother are legally separated or were never married, the grandmother qualified. She also qualified under provision 5 of this statute because the child had lived in her home for more than 12 months. And it's undisputed that the parents restricted the grandparents' visitation. Because the child lived in the home of the grandparents, there was a rebuttable presumption that the denial of this visitation may result in irreparable harm. And it was only if the court found substantial harm or irreparable harm could the court determine if the visitation was in the best interest. In the matter before the court, I submit that the father in this case rebutted the presumption that there would be irreparable harm if the trial court failed to order grandparent visitation.
Is that what the trial court found?
Yes, the trial court found that there would be no substantial harm if there was no visitation, that it wasn't proven that there would be substantial harm.
Isn't that just kind of backwards of what we're talking about here?
I don't understand the question.
Well, according to opposing counsel, the trial court put the burden of proof on his client.
Your Honor, the burden of proof was, with the rebuttable presumption, she didn't have initially the burden of proof. But once Trey Browder, who was the first witness, testified, and he testified that not only would there be no substantial harm by the court not ordering visitation, in fact, there would be substantial harm if this court ordered visitation in light of the toxic relationship involving Roger Cherry, Mrs. Cherry's husband. And the therapist elaborated, and specifically on page 11 of the record, he said Eli would not suffer any significant harm if visitation was not court ordered, and went on to state that if forced to go with the grandparents, it would continue to cause the same level of significant stress and anxiety that Eli had been experiencing up to that point. He elaborated by stating that the conflict was having a significant effect on him emotionally and was carrying into his academics as well as the time with his parent. And I asked...
Let me
Sure.
back up and make sure that we're on the same page here and we're talking about the same thing. Opposing counsel says that the trial court required him to prove that harm would exist if no visitation occurred.
That's correct, after the father rebutted the presumption. Then the burden shifted.
Did the trial court start out with the rebuttable presumption that denial of visitation may result in irreparable harm to the child.
He didn't specifically say that in his ruling. He didn't say that the father, in fact, rebutted the presumption. There was another issue going on that
So,
the grandparent didn't clarify whether she was proceeding under 366306A, which doesn't, A2, which doesn't require the rebuttable presumption. She doesn't get the benefit of a rebuttable presumption under A2 of the statute. She only gets the rebuttable presumption under provision A5 of the statute.
I'm aware of that.
Yes. And so, but our position is either way, it was rebutted with the testimony of the counselor in this cause.
Did the trial court ever say anything about who had the burden of proof in this matter?
He did not. He did not, Your Honor. But the proof in this case I submit to the court was overwhelming of the harm being rendered to this child in the home of the grandparents. There was testimony that this grandfather referred to the father as a botched abortion, four-eyed moron, referred to the mother and her new husband as immigrants. They had moved to Florida. He recounted that this child was emotional and cried in sharing with him what the grandfather was doing to him. And understand, the grandparents only had 3 visits since 21. There were only 3 visits. And while the grandmother would like to say that the father denied the visit between her and this child for the first 2 visits, in fact, the child came to her car. They sat in the car. They talked for 30 minutes. After that, the grandmother left, leaving the child with the father. That happened on the first visit. The second visit, she picked the child up. Child's in her car. They visit for 30 minutes. Child gets out of her car and goes back into the home of the father. The third visit, she brings the police. The fourth visit, she brings the police. On the 5th visit, and this is one where it was actually the third, that the visit actually took place over the course of the weekend. The visit was terminated early because the grandfather started, again, speaking in a derogatory manner about his parents, and the child asked to leave early. And even though this was only the 3rd visit in a matter of years, the grandmother picked the child up and took the child back home. There have been no further visits. So I submit to this court that there is no finding of substantial harm by this court failing to order visits, and the grandparents' petition for grandparents' visitation should be denied.
Thank you.
That's it. Thank you.
Just briefly, if I may, I didn't get into the statements about what they were saying about Roger Cherry, but it's important to look at the record to show that those statements were not heard. Any statements about Mr. Huffman were not heard by the child, but from Mr. Cherry. They were heard from Mr. Huffman. And that's why I was recanting what he did in this case, denying the visitation, taking the child to Mississippi, all of that. And the record shows that when the child finally went to counseling after Mr. Huffman was cited for contempt, that Mr. Huffman was always present when the child was with the counselor. So I think all of that shows that it was Mr. Huffman expressing his views about certain things and letting the child hear it all. But the important thing that we need to get to on the burden of proof, on page 82 of the transcript, the court says, in directing towards me about Ms. Ball's motion to dismiss, I think the burden is on you to show that the child would be harmed if he did not visit. That shows he was misreading the statute, and specifically 306A5 places the burden on Mr. Huffman once once that's established, to show that there would be harm to the child. Now,
Is
Ms.
that the
Ball
only
wants to
time
come
the
up
court-
and say, because we took this out of turn,
Is that the only time the court says that?
excuse me?
Is that the only time the court talks about the burden of proof?
Yes, he references some other things, but that is the only time. But once they do that, because of the procedural aspect of this, and that's why I was getting at it, this wasn't a full hearing. Ms. Ball didn't put on all of her proof. The the counselor was taken out of turn. So for the purpose of the motion to dismiss, the only evidence was the testimony of my client, Cherry Hollie, and her sister, Jennifer Timms.
Were you prohibited from putting on additional proof?
No, they were not. Nobody was prohibited at that point. We rested, and then Ms. Ball moved to dismiss after taking the counselor out of turn. So my position is that shouldn't even be considered on the motion to dismiss, but even if you do, it really doesn't matter because the judge did not correctly interpret the statute. And so based on that, the burden was on Mr. Huffman, not upon Ms. Cherry. Thank you, Your Honor.
Thank you, counsel. We will review the record and will endeavor to get an opinion filed at the earliest possible time. You may be excused.